Greetings to students and upcoming lawyers. Today I'm going to speak on sources of Muslim law, which is a very prominent question from examination point of view. For detailed custom notes and exam guidance, contact to the number given 7019560214.
Before we get into the sources of Muslim law, it is important for us to understand what is Islam. Here, Muslim law in India is that portion of Islamic civil law which is applicable on the Muslims in their personal dealings, in their personal matters. And Islam can be understood in two senses. One is from the religious sense, other one is from the secular sense. From the religious sense, it is submitting to the will of God. And here, God is considered to be the legislator, and God alone is the legislator in Islam. And here they believe in the totality of Allah's command. And Quran is considered to be the holy book. From the secular sense, meaning to the term Islam is to establish the peace. And Quran is founded on Quran. Quran means Al-Furqan. Al-Furqan is something which shows truth from falsehood, right from wrong. And Quran is based on one very basic principle called, it's an Arabic principle called La ilaha illallah Muhammadur Rasulullah. That means there is no God but Allah, and Prophet Muhammad is the messenger. It says there's only one God, Allah, and Muhammad is the messenger. And from this very principle, we get two characteristic features, which we call it to be the tenets, two basic tenets of Islam. One is principle of unity of God, believing in oneness of God. Second one is believing in the prophethood. This is an introduction to what is Islam. Now, speaking of sources to Muslim law, sources are categorized into two. One, we have primary sources, other one, we have secondary sources. From the second primary sources, we have Quran, Sunnah and Hadith, Ijma, Qiyas. And in the secondary source, we have custom, legislation, judicial decisions, and the last one is justice, equity, and good conscience. And we'll get into the details of the sources. Speaking of the primary sources are those sources which the Prophet himself directed it to be the very source to Islamic law, where whole of the Muslim personal law is based on the primary sources, and they are also called as formal sources of Muslim law. First, we have Quran. The word Quran has been derived from the Arabic word called Qurra. Qurra means to read. And Quran contains the very words of God as they were communicated. The verses of Quran were communicated to Prophet through an angel. It was through an angel Gabriel. It was from God to Prophet through an angel Gabriel. And this Quran is considered to be the very source, very divine source, and it's the original source because it has been revealed by the God himself, and it has got the universal authority. The first revelation which was given to Prophet was the term Iqra. Iqra means to read. Iqra means to read. Actually, there is one IAS academy by name Iqra. It is influenced by this term Iqra. Iqra means to read. So Islam gave importance to knowledge. So the first revelation Wahi which was given to Prophet was Iqra. It came to Prophet in the year 906 AD. Since then, it started to reveal to the Prophet in fragments. Fragments in the sense it was bit by bit. Bit by bit it used to come to Prophet, and it continued for 23 years. And it lasted till to 632 AD. It started in 609 AD and continued till 632 AD. And when a prophet expired. And that's the reason why Quran is considered to be the divine, because it is believed to be the very words of the God. That's the introduction to what is Quran. Now, speaking of structure of Quran, how Quran is structured. First, Quran is in a verse form. Verse is called ayat. Ayat means verse. Each verse is called ayat, and Quran contains 114 chapters. Each chapter, in Urdu we call it surah. It is called as surah. 114 surahs, and it has got 6 ayat. 6,666 ayats, and it is divided into 30 paras. It's in parts, chapters, and verses. Parts are called as para, verses are called as ayat, chapters are called as surah. First surah of Quran is Suratul Fatiha. Fatiha in the sense introduction. It's a very introduction to Quran. It's like preamble to the Quran. We can call it to be the preamble to the Quran. We will be able to get entire gist of the Quran in this very surah called Surah Al-Fatiha. It's the introduction, preamble Quran, and it consists of verses in praise of Almighty God Allah. And we have other important surahs called Surah An-Nisa. Surah An-Nisa is relating to the women, and Ikhlas is about absolute surrendering to God, and Surah An-Nur is about the home life. This is the structure. And speaking of structurization, continuing with the structurization, in total, the verses relating to law are 200. Out of this through 200, only 80 verses are related to family, and rest all relates to marriage, dower, divorce, guardian inheritance. And the Quran was revealed in Makkah and also in Medina. The black stone, what we find, the black stone is in Makkah. The place where the Prophet is resting is Medina. Makkah is where the revelations relating to theology was revealed. Theology in the sense religious. Theology is nothing but study of religion. So pertaining to the religious affairs, the revelation came to Prophet in Makkah. In Medina, it was more of socio-economic laws. And so it is not more of a legal code. Rather, it just lay down the principles how a man is to regulate the life, how is he to deal with the other human beings and with the God. And then Quran is considered to be the first source. Quran is the first and fundamental source of Islam. In the present Muslim religion, Quran was the present Islamic religion was born with the very words of God. Any study of Islamic law will always begin with Quran. So Quran is the first source. Second, it's a divine source. Quran is of a divine source. It is believed in Islam that words and the words of holy books are made by the Prophet himself. It made by the God. Sorry, it's not Prophet. It's made by the God himself, given to Prophet. And these are not the words of human being. So these cannot be changed at any cost. So that is why they say it is unchangeable. Unchangeable. To support this, we also had certain judgments given by the court of law. Agha Muhammad Jafar versus Kulsum Bibi and Ibrahim Fatima versus Muhammad Salim. In this cases, the court validated the unchangeability of Quran. Quran cannot be changed because these are the very words of the God. Then Quran is mixture of religion, law, morality. Religion, law, or morality are at and mixed in one place, and it is and in such a manner it is difficult to separate them. Then it is different forms of legal rules have been mentioned. We have rulings pertaining to child infancy, unlimited polygamy, and then gambling is not allowed, and charging interest loans are strictly prohibited in Islam. All these rulings will be getting in the Quran itself. And then we have incompleteness. Quran is not a complete code of Muslim personal law. It generally contains verses relating to philosophy of life and religion. It is only, as we already discussed, it only consists of 200 verses, out of which 80 are related to law, and rest all it's about the marriage, divorce, and all that. And then Quran is silent on certain matters. That's the reason why Quran was supplemented by another source called Sunnah and Ahadith. Next, second source we have here is Sunnah. Sunnah means model behavior of Prophet. The way how Prophet used to behave is Sunnah. And Sunnah is divided into three. Ahadith is what Prophet said, did, and allowed is Ahadith. The way how Prophet led was Sunnah. Here, Sunnah is divided into three types. In English, it is called as traditions of Prophet. Sunnah in English is called as tradition of Prophet. Sunnah is divided into three. First is Sunnatul Fail. Sunnatul Fail in the cells, it is the conduct. Where it includes doing of Prophet, the behavior, how Prophet used to behave. It's about traditions, about how the Prophet used to lead his life is Sunnatul Fail, conduct. Sunnatul Haul is what's spoken, utterances, which the something which were uttered by Prophet, sayings of Prophet Muhammad is Sunnatul Haul. Taqreer is silence. Here, something which was done in presence of the Prophet, but without the disapproval. Sometimes what happens, when children in the school playing in the playground and the principal is noticing it, principal did not object. Principal silently observed it and just moved from that place. Here, it is impliedly understandable there is a consent of the principal. I'm just giving an example. Taqreer means sometimes silence of a person is considered to be the consent. That is taqreer. We have three types here in Sunnah. One is Sunnatul Fail, Sunnatul Qawl, Sunnatul Taqreer. Fail is conduct, Qawl is word spoken, Taqreer is silence. And speaking of ahadith is of three types. Ahadith mutawattir, hadith mashhur, hadith wahid. Mutawattir means universally accepted tradition. It is followed by all sects of Islam, Shia, Sunni, every person, irrespective of their belief system, will follow this ahadith mutawattir. And then mashhur. Mashhur is a daily used term. In daily parlance, we use this term mashhur. Mashhur means famous, popular. So popular tradition is mashhur. Majority of people do not possess the character of universal propriety. That's it's just famous, a tradition which is famous. And wahid means traditions which depends on isolated individuals. And then there is one authentic collection of prophet's sayings called Sahih al-Bukhari. After Quran, most authentic Islamic book is Sahih al-Bukhari. Sahih al-Bukhari is the compilation of Prophet saying. There was a person who, after the death of the Prophet, used to visit Prophet's companions, and he collected a book. He collected the revelations, collected the sayings and the doings of Prophets, and compiled a book called Sahih al-Bukhari. Sahih al-Bukhari is the most authentic collection of the teachings and the sayings of the Prophet Muhammad. This is about the first and the second source. Speaking of the third source, we have ijma. Ijma means opinion of Muslim jurists. Ijma means opinion of Muslim jurists. We have Sir Abdul Rahim, who said ijma is nothing but agreement of jurists um, among the followers of Prophet in a particular age on a particular question of law. Best example is during the time of Prophet, there was no technology. Nothing used to happen online. These days, marriages are happening online. Girl sitting in Bangalore, guy is in America, marriages are happening online. Now, the question is whether this kind of marriages will be valid. Many things are happening online. So now the validity of these things will be questioned and will be decided by the Islamic jury. That is called as ijma. Ijma means agreement in a particular age on a particular question of law. The persons who have got the knowledge of Islamic law is called mujtahidis. They are called as mujtahidis. There's a spelling mistake here. Mutahids I've written. It's not muatahids, it's mujtahidis. Mujtahidis means the one who is well versed with the Islamic law. Now, what are the essential requirements of valid ijma? First, consensus. The majority of the jurists are of the view that anonymity is a prerequisite. Anonymity, consensus addendum. We use the term in law, consensus addendum. That is meeting up of the mind. Mind of two people should meet. Mind of the jurists should meet to come to a conclusion as to a question of law. That is the first essential. Speaking of the second essential, the one who is giving the opinion must be a jury. Jury in the sense someone who is well versed with Islamic law. For a person to become a well versed, he will have to go through certain years of study of Islamic law. I think it's almost 5 years of Alima course. Only then he will become a jury in the law. So in every field of knowledge, only the opinion of the experts are admissible, since the jury will be someone who will have the knowledge in the field. And then jury must be Muslim. And any opinion given by the non-Muslim will not be taken into consideration, will not be admissible. The one who is giving opinion must be a Muslim and also must be well versed with the Islamic law, must have the degree. I mean, there is one alima course, and then there is jury of a particular period. There would be no law laid down by ijma during the prophetic time of time. So here, these are the questions which are after the prophetic time. And this consensus, that is, opinion must be on the religious matters. So these are the 5 essential requirements of ijma. That is agreement among the followers of Prophet on a particular question of law in a particular period of time. And then the one who is well versed with the knowledge of Islam is called mujtahidis. And then we have categories of ijma. Ijma is categorized into three. Sorry, it's not two, it's 3. One is ijma of companions of Prophet. It's universally accepted throughout the world. And ijma of jurists. Yes, decisions given by the jury. Third is ijma of people. Ijma of people have no value. People will say a lot, which will definitely have no value. So people giving opinion will not have value. Though it is relating to the Islam, but it will not have value. 3 jurists. Ijma of companions of the Prophet, ijma of the jurist, ijma of people. And when Quran and traditions could not supply any rule of law for a new problem, then the jury's opinion will be given importance, and the jury in the law is called as mujtahidis. And then we have qiyas. Qiyas is analogical deduction. Analogical deduction in the sense we refer to first three sources and will come to a conclusion. We'll compare and we'll come to a conclusion. Analogy is kind of comparing and giving an example. That's the meaning to the term analogy. We usually use the term analogy. It's just an analogy. It's just an analogy. Analogy is nothing but comparison between two things that shows a way in which they are similar. That is the meaning to the term analogy in our day-to-day parlance, the term what we use here. Analogical deduction in the sense we refer to the first three sources and come to a conclusion. So the last primary source of Muslim law is qiyas. Qiyas means reasoning by analogy from above three sources, that is Quran, Sunnah, and Ijma. For analogy to be valid, it must be by a person who is a jury, that is mujtahidis, and it must be deducted by referring to Quran, Hadith, and Sunnah and Ijma. This is all about primary sources to Muslim law. And this is just a very quick information about the classes available. If you are in need of handwritten notes, classes, and guidance, you can contact to the number given. So if you will assure the quality learning and will keep a watch on your preparation, you can just call to the number and enroll for the same. Now, speaking of secondary sources are modification of primary sources of Muslim personal law as society changes from time to time. And then for that reason, there's also importance given to the secondary sources. Secondary sources are called as extraneous sources. In the secondary sources, we have the first source called custom. Customs were never considered to be the source, but later customary law exists in Islamic law is given importance only when it fulfills following essentials. Number one, it must be reasonable, it must be ancient, and must not go against the text of Quran and Sunnah, and it must be universal and conformity with the Quran and Sunnah, and it must be consistent with Quran and not opposed to public policy. It must be unambiguous. And unambiguous in the sense it should not lead to confusion. Unambiguity in the sense something which do not lead to confusion is unambiguity. It should not lead to confusion. And it must also assure the peaceful enjoyment, and it must be certain. There was immemorial antiquity. It must have immemorial antiquity. For that, we have a case, Abdul Hussain versus Sona Deru case, where the court observed custom could prevail over written text of law when the custom is ancient, valid, not contrary to the Quran and Sunnah and Ahadith. In the present scenario, what is the status of custom? For this, we have Section 2 of Muslim Personal Law Shariat Application Act of 1937, wherein it says, pertaining to 10 matters, marriage, dissolution of marriage, talaq, ila, zihar, lian, hula, mubarat, maintenance, dower, guardianship, gift, trust properties, and waqf. Pertaining to these many matters, if both the parties are Muslims, then it is personal Muslim law, customary law is to be followed. Personal Muslim law is to be followed. That is the importance of custom. And we do give importance to custom pertaining to marriage, pertaining to maintenance, dower, guardianship, gift, trust property, and waqf. Speaking of judicial decisions have also played a very important role in Islamic law, and judgments of the superior courts have also been always played an important role. We use the term precedent, and there was a very famous case, Shahbanu Begum case versus Union of versus Muhammad Ahmad Khan, where after this case the court came up with Parliament of India came up with the law called Muslim Women Protection of Rights on Divorce Act of 1986, and judicial decisions have always been played an important role in the present scenario. Then legislations. Though Muhammadan law in India is not codified, there are some aspects of Muhammadan law that have been regulated by acts of legislature. We have Shariat Act of 1937, Dissolution of Marriage Act, Waqf Act, Musalman Waqf Validating Act of 1930. And last is justice, equity, and good conscience. If we are not able to get reference from any of the above source, then we are going to give importance to the last source called justice, equity, and good conscience. So justice, equity, good conscience was given importance by Abu Hanifa. Abu Hanifa was the founder of Hanafi school. Majority of Muslims in the world, not only in India, in the world, follow Abu Hanifa's school of thought. Abu Hanifa will be discussing that in detail when we deal with the schools of Muslim law. Speaking of this, equity, justice, and good conscience, Abu Hanifa, founder of Hanafi school, gave importance. He used the term istihsan. He said justice, equity, and good conscience is istihsan. And it's kind of liberal, giving importance to justice, equity, good conscience, and coming to a conclusion. Then comes conclusion. Yes, from the above detailed discussion, it is very much clear the very source to the Islamic law is Quran, which is considered to be the divine law. It has got eternal existence. It is considered to be the very words of the God because it was given by the God to the prophet through an angel called Gabriel. And later, after Quran is supplemented by other sources as well. Quran, Sunnah, Ahadith, Ijma, Qiyas. And in the secondary source, we do have custom, judicial decision, legislation, equity, justice, and good conscience. So this is all about sources of Muslim law. If you have any special request, you can contact to us on our on the given number. See you all in the next video. All the best for your upcoming exam. You're hardly left with 19 days for your exam. Any queries, you can contact us.